Commissioner Bushnell.
Me.
Good afternoon. First and foremost, thank you all. It's been a long trial, and I recognize that. I recognize it's been a long day. I will try and be very brief. Let's start with the allegations for the security uniforms. The way I view it, the state wants to have their cake and eat it too. They want it both ways. By their own testimony, non-security can't carry guns. Okay. You are security, so you have to have badges on your uniforms. But you're not security, you don't have the authority to remove anybody from the facility. But you are security, so you have to have a contract conveying the authority that you don't have to remove people from the facility. They flip-flop back and forth all the way through. The reality is, and the jury instruction has it in there, and you'll have the city municipal code key phrase, in the business zone. Of course, KCRCC is a professional to volunteer his time and give them assistance with security. Probably wouldn't want somebody who had no idea what they were doing. Yes, they discussed the contract, they discussed hiring Lear, but they didn't. And ultimately, the decision was made by both my client, Paul Trouette, and all the other members there, that they were just going to be volunteers. They were just there to help out. They were there to give assistance to KCRCC if they could. But then something else happened. They get approached by the sheriff of Coogee County, who has just been informed that there is a bomb threat against life, active situation going on, with good belief that this venue is the target of that threat because of one of the speakers and his family being present. The sheriff grabs Paul, all the other guys, informs them of this, asks them to help him look for this individual, keep checking the parking lot, check inside. Real threat. They all comply. Now, when we wonder or think about what it means to be in the business of, what it means to be volunteer, whether or not somebody who volunteers as a security guard or as security to assist, I think it's helpful to think of other points in your life where you've seen security. They are obviously helping. They're obviously there for that purpose, that aren't plastered in the uniforms. Thank God. My church has guys stand around the entrances. At various small events, the bouncer of a local bar. Places have people, but in this instance, that key statement, in the business zone. The officer, Officer Bushnell, the SRO, specifically highlights all the reasons why they weren't actual security, and therefore were not able to carry firearms. I won't belabor that point. It's going to come down to your analysis of those fine-tuned in the business of whether they were volunteers. Answer the question whether or not they were security, whether or not that statute applies. The rest of the counts. In some ways, I agree with Mr. Hunter's analysis. There's overwhelming amount of evidence. In fact, So much so that roughly 30 minutes of time required a 3-day-long jury trial, hours of video that you've been provided in evidence. I, too, strongly encourage you to go and watch that. I would encourage you to, whatever view, find one and actually watch it start to finish. Because what it shows is an extremely fluid situation with one law enforcement officer who has the authority to give commands, and the 6 security guys that he'd already talked to, already asked and requested their help on another separate issue, and watch his behavior. The sheriff is acting like he has the ability and is commanding, and these guys are helping him the entire way. It's not because some random stranger saw an officer and just walked up and started helping him do his job. They've been introduced before. The sheriff had already used their services, and through the totality of the chaotic event, the sheriff is acting as if everyone involved is helping him. He is relying on their help. You hear him multiple times ask for more security. I need more guys to come help me deal with this. Imagine if nobody was there to help. Both Greg Johnson and Sarah Forsgren were starting to interfere. First verbally, but go watch the video, you'll see Greg's starting to walk back towards it. He didn't like the way they were acting. Just like Teresa didn't like the way the town hall was conducted. There was only one law enforcement officer there. It was getting heated. Put yourself in that position. But also think of the consequence of this kind of allegation. This statute exists for a reason. The legislature gave us a statute where a law enforcement officer can be engaged in their duties and request the help of citizens. And if those citizens help, they're protected. They're protected because the legislature wants law enforcement to be able to depend on help if there's none else available. They want you to feel safe, or at least feel confident in the fact that if you get requested of you by a law enforcement officer, you can just do it. You don't have to stop and think, well, does this law enforcement officer have probable cause to be arresting this individual? I'm not sure if that individual has lawfully read their Miranda rights. I don't know if I can help you, officer. I don't want to interfere lest I get charged with battery, false imprisonment. The state had you believe that there was some kind of conspiracy going on, and it was all directed at Trace Warrenpool, and anybody who got in the way got caught up in that. But again, watch it from start to finish. What you'll see is, yes, other people were saying things, the temperature was rising, but there was one individual who was actually arguing back and forth with the MC. That was Teresa Warren. That's why the sheriff went to her. And you heard his testimony. He just wanted to remove her, let the situation calm down, tell her that she needed to correct her behavior. But she utterly refused well after she recognized him as the sheriff of Coogee County because she didn't think he had jurisdiction. The sheriff is required to perform the following duties: preserve the peace, arrest and take before the nearest magistrate for examination all persons who attempt to commit or have committed a public offense, prevent and suppress all affrays, breaches of the peace, riots and insurrections that may come to his knowledge, and command the assistance. He's required required to command the assistance. He's required to prevent a phrase. The state has been hammering on and on and on. It's yelling a profanity, a violation of law. Did the CRCC convey, or did they even possess the right to trespass people because this was a school and the school has policies? The sheriff is commanded to prevent a phrase. He is commanded to keep the peace. He could have been walking by, stumbled into that school to see what's going on, seen it going awry, just people yelling left and right, nobody listening to the MC, and he could have commanded the assistance of half a dozen men and asked them to help him calm this down, help me remove people, tell the MC to stop talking. He has the lawful duty, not just the authority, he has the responsibility as his office as the sheriff of Coogee County. That's his job. It doesn't matter even if those individuals were committing crime. They were a part of an affray. Nowhere in here does it say he has to cite them. Nowhere in here does it say he has to take them to jail. But he's to prevent it. He's to take action. And he's commanded to gain the aid of as many people as he deems necessary in order to accomplish that. And then it comes down to the very previous. There's two versions of it. One says battery is lawful if, and one says false imprisonment is lawful if committed by an inhabitant of the county who has been commanded by the sheriff to aid in the exercise of the sheriff's duties. Now the state would have you read that so narrowly as to remove your common sense. Nowhere in these jury instructions does it say a command by the sheriff must be given verbally and affirmatively in X format, because that's ridiculous. The sheriff testified that at multiple points he had given clear commands. Keep the hallway clear. Hold on to it. I need 2 security guys over here. Give me 2 more security guys. There were clear commands, but there's also one sheriff. There's 5 other security guys, multiple individuals causing. Like, how is the sheriff supposed to be in all places at once? Now you can grab her arm. Now walk her to the door. Now put her up against the wall. Now you can grab the leg. Now that's ridiculous. It is ridiculous to think that this statute, that this protection requires a play-by-play command by the sheriff in order for it to carry its effect. Again, watch the whole video. It is obvious that the sheriff has already conferred with these security officers, these security guys, security men. He has become reliant upon their help, and when things start going crazy, notice what he doesn't do. He never stops and tells them to stop. He is obviously accepting their aid. He is obviously wanting of their aid. He calls for it multiple times. Ms. Bornpole testified specifically that even if she doesn't know the law, she's still subject to it. She testified that she didn't know the laws relating to the sheriff or his duties. In fact, none of the state's witnesses did. I should say no. None of the state's alleged victims did. But again, nowhere in the sheriff's duties or authorities does it say that in order to remove somebody from a building, they must have committed a crime. It's not there. It's not in your jury. This is a copy of That's Exhibit B, going back here with you guys. You heard quite a bit about it. I'll only highlight this. You heard state produced evidence, witnesses, law enforcement officers did an investigation, Chief Haley's investigation, and he sees things different. Mr. Hunter has pointed out in videos how he perceives it. This is another. It's somebody else's opinion on how they perceive the whole thing. You guys are gonna have your own. You guys are gonna have, we don't know exactly what all evidence they had testified to, that it seems likely that most of the evidence that you guys are gonna have, you'll come to your own conclusions as well. But I would highlight for you specifically what their finding was, which was that the sheriff of Cooney County didn't commit a crime. The sheriff didn't commit a crime, and he commanded the aid of all these other individuals. And the statute says that you help the sheriff. It's not a crime. Then how can Paul Trouette be guilty of any battery or any false arrest? And there's one count that Greg Johnson. What an absurd contention. That when you aid the sheriff specifically, just the two of you, and walk a man out under the sheriff's authority, and the sheriff says stay with them, keep the hallway clear, that now somehow you're committing a false imprisonment or battery. That is what the state's entire case is based on. Those jumps, absence of logic, absence of the obvious legislative intent for why we want people to assist our law enforcement officers. Grant protection for it. For those reasons, I'm asking to return not guilty